Hello, everybody. I won't say good morning or good afternoon or whatever because I don't know what time of day it is with you, but you're very welcome. You might have just heard that this is being recorded in case you have to bail out at any time. You can catch the rest of it. I'm very, very pleased to be able to introduce our speaker, Derek Marshall. Hopefully, you've had a chance to Google him. If he wants to say anything more about himself, but uh, you, he may well do so. If you're ready, Derek, can I pass over to you, please?
Thank you very much indeed, Dave. Hello, everybody. It's nice to see you all. It's nice to see people who've left their cameras on so I can see who I'm talking to. So I'm coming to you from what looks like a fairly bland office. But if I turn my camera around momentarily, you'll see that I am there. I'm at Exeter Racecourse at the moment. And the reason for that is not because I'm having a punt on the horses. It's because Exeter Racecourse has a conference centre and it's used by the Police and Crime Commissioner for dealing with disciplinary cases. And I'm currently sitting on a panel which is going to resume at 10 this morning. And that's one of my hats, is sitting on the police misconduct panel. Another is, and I've been doing it for about 17, 18 years now, working as a civil dispute mediator and also as a private FDR judge and private ENE judge or assessor. And we'll be talking a little bit about that later on. I'm also the retired head of college chambers. So I've got a long history of practicing in the law in the south coast of England. You probably looked me up. And this talk I'm going to be doing today is one of a series of talks we've been doing in chambers. And I can show you at the end of this session a QR code where you can put your camera at the screen and contact chambers if you're interested in any of the other subjects we've been talking about in the past. And there's still one more to go in the future. So I'm going to be talking to you about non-court-based dispute resolution. Can everybody hear me? I've got a message up saying unmute. You can all hear me. Good, I keep going. Okay, I think that's just a rogue message that popped up saying unmute. So going back to my theme, this talk is based upon the law of privilege and whether there are new developments in the law so as to give rise to a new jurisprudence of mediation privilege. We need to go back a little stage and ask ourselves what privilege is actually all about when it arises. At least one person on this call has already identified the picture that you can see in front of you. And for those my age, everybody will know immediately that it's the Pink Floyd Wish You Were Here album cover. And you may also remember that the chap who's on fire in that picture died recently at a great old age, having spent most of his career being set on fire as a stuntman. And there's a reason why this picture is here. It's a pictorial allegory. And whilst I talk, I'll let you work out what the allegory actually is. So for privilege to arise, it requires a number of things. First of all, it requires negotiations. And negotiations will take place in the court. And the reason why I pause momentarily, I keep getting this message to unmute, but I'm assuming you can all still hear me. In order for negotiations to arise, a number of conditions are required. First of all, there has to be obviously a dispute. And a dispute leading to a process of resolution which will arise by way of offer and acceptance, leading to an agreement. And now we come to the pictorial allegory. These two chaps are shaking hands, which is what you do when you reach an agreement. But some deals quite literally burn you. And that is the problem that we're going to be talking about today. What is meant by without prejudice? Some of you will recognize this handsome young chap. those of you who are thinking who he might be, I'll tell you at the end of this particular slide. What is meant by without prejudice? Well, without prejudice clearly means that the maker of the statement headed without prejudice is putting forward some genuine proposals of settlement terms, as opposed to stating their case or putting forward an argument, which is quite often what's done in letters that are marked without prejudice but aren't really. And they're genuine proposals between parties to a dispute, and that's important, and for the purpose of trying to settle the difference between them. And they're put forward on the basis that they're not to be relied upon by the other party if no settlement is actually achieved. And the authority for that is a case called Rush and Tompkins versus the GLC. And you'll now understand why Ken Livingstone is there, because, of course, he was famously the leader of the Greater London Council before he became a Member of Parliament. So that's what it means. There's the reference to it, 1989 AC 1280. And Lord Griffiths, in that case, explained that what this means is without prejudice to the position of the maker of the offer if it's not accepted, the underlying purpose being to protect the litigant from being embarrassed by any admission made purely in an attempt to achieve a settlement of the case. Now, why? Why do we do this? When I was a very young barrister in the early 1980s, there was a gentleman in Hampshire called Oliver Cutts. And Oliver Cutts was pretty close to being a vexatious litigant. He was forever getting involved in legal spats. But he had two redeeming qualities. One is he was usually right, and the other is he put a lot of work my chamber's way. And he features in the next slide, which deals with the question of why. Why do we have this? And the reason why is that parties should be encouraged so far as possible to settle their disputes without resort to litigation, and in the knowledge that what they say can't actually be used against them in the event that the proceedings or the settlement negotiations don't lead to a settlement. They should be able to put forward their position and their offers fully and frankly. And the purpose of this is that there's a public objective in having matters settled out of court rather than being litigated. The rule applies to exclude all negotiations aimed at settlement, whether oral or in writing. And here we come to Oliver Cutts. That's a famous statement of the law from the decision in Cutts and Head, and the reference is there for you to see. What's covered? Well, what's covered is a surprising amount, actually. And the basic rule is called the ocean bulk rule. And it's not limited to the situation or cases where the negotiations do or don't produce a settlement agreement. It makes everything admissible, including subsequent matters which are connected with the subject matter, provided those statements are made with a genuine intention of reaching a settlement. And it will also cover other different parties within the litigation so as to prevent the admission of things said and things done, or both orally and in writing, with the aim of achieving a settlement. As with everything in the law, there are exceptions, and these are called the Unilever exceptions. And there are some of Unilever's products. So these are the exceptions to where privilege will not apply following without prejudice correspondence or conversations. And the first and most obvious is that it may be possible, and it very often is necessary, to open up what was said between the parties in the course of those discussions to figure out whether there really was a concluded agreement. There's an interesting passage in the case of Rush and Tompkins, which we looked at earlier, in which one of the judges says, well, what you've got to do in this situation is to consider the small bundle of without prejudice correspondence and ask yourself the question, are the essentials of offer, acceptance, consideration and an intention to create legal relations actually there? And if they are, then there's a concluded agreement and the court's entitled to look at what took place, even under the cover of the without prejudice privilege, because you're deciding whether they actually reached a deal. That's the first and most important exception. Secondly, the privilege may be lost where the agreement has been achieved by misrepresentation or fraud or undue influence, and somebody asks the court to set it aside for those reasons. This is why in mediation we very often find ourselves in the situation in which the parties ask each other questions, factual questions, and as mediators we're obliged to say to the party who receives those questions, well, you don't have to answer the question if you don't want to, but if you do, it's going to have to be a truthful question, because if it's a truthful answer rather, because if it's an untruthful answer, all that's going to happen is there'll be an application subsequently to set aside the agreement because you didn't tell the truth in answer to the question that was put forward, and there'll be a misrepresentation or fraud claim. The privilege can also be lost in the case of estoppel or unjust enrichment, which is perhaps less likely to happen in mediation agreements, or where the exclusion of the evidence would act as a bar or to allow blackmail or some other unambiguous impropriety to go unpunished, as it were. It may be lost when it's necessary to consider what took place in order to explain delay or apparent acquiescence, and also whether the claimant has acted reasonably or unreasonably to mitigate their loss. Then, of course, there's the familiar situation where offers are made expressly without prejudice, save as to costs, and there the privilege may end if the matter then goes to litigation and one or other party is successful beyond their wildest expectations, and the offers are put forward to the judge to say, well, we could have settled for a lot less than this, but we can show you this because we made an offer without prejudice except as to costs. There's some jurisprudence about whether communications received in confidence with a view to marriage conciliation could be accepted. I don't think I'm going to go into that too much because it's a rather unusual and esoteric element. And those exceptions come from the decision in Unilever and Procter and Gamble in 2000. And those are, as they say, the Unilever exceptions. The extent of the Unilever exceptions is really this. Lord Clarke in Ocean Bulk said the list of potential exceptions are non-exhaustive, and Lord Phillips said that when construing a contract between two parties, evidence of fact within their common knowledge is admissible where those facts have a bearing on the meaning that should be given to the words of the contract, and that can be so even when the knowledge of those facts is conveyed by one party to the other in the course of negotiations that are conducted without prejudice. This applies to contracts that result from without prejudice negotiations and in the course of other subsequent contracts concluded between the parties. So that might, for example, mean, I'm going back to the previous slide, that documents disclosed during the course of mediation will not thereby be excluded simply because they were produced in the course of mediation, because they're disclosable anyway and they contain facts which become material to subsequent events. So that's the common law position. When parties enter into a mediation, of course, they do so on the basis of an agreement to mediate. And like all of you, my chambers has clear contractual conditions in the mediation agreement. And the mediation agreement gives rise to contractual obligations between the parties about what they can and cannot say and do following the course of the mediation, whether successful or unsuccessful. And these are some of the common terms that are included within certainly my chambers, and I'm sure most of your chambers and firms' mediation agreements. So the parties agree that they can't call the mediator as a witness or an expert, except where they and the mediator agree in writing. The mediation is confidential and without prejudice. We say all offers, promises and statements made in the course of mediation, whether orally or in writing, to remain privileged, so the parties have contracted to the common law position. And there are exceptions. So certainly our agreement says that if an agreement is reached at mediation between the parties, any disclosure required for the implementation or execution of the agreement can be made. And of course, evidence which will be disclosable in a court of law isn't rendered inadmissible just because of its production in mediation. Very commonly, one finds documents being handed over in mediation. That doesn't mean to say that they're exempt from the usual disclosure process. We have a specific clause in our contract, and I imagine many of you will do so, which says that any information coming to the knowledge of the mediator or the parties which gives rise to a risk of serious injury to anybody, then the duty of confidentiality can terminate. And it also can be terminated if the mediator comes under an overriding legal or moral duty to make disclosure to the police or other public authorities. Again, common clauses. And then there are additions to our agreement. If agreement is reached between the parties on discrete issues are resolved, then the parties must execute heads of agreement for signature. The agreement isn't binding until it is reduced into writing in the usual way. So we come to the nub of this talk. Is there a special category of mediation privilege? And here we have the question, does the computer say yes or no? Phipson, in its latest edition on the law of evidence, says that although some commentators have suggested there is a special type of privilege in relation to mediation, the authors of that work don't think that it actually exists. And they base that view largely on a case called Brown and Rice in 2007, where counsel put forward various propositions relating to mediation privilege, which was an unsuccessful argument. Of course, the thing about Brown and Rice is it was decided a long time ago, back in 2007, when mediation was thought not to be something that the courts could order or direct. Mediation law has moved on quite a long way since then, because we've got the Churchill decision. So it may be that's not correct. However, despite the Churchill decision, the editors of Phipson still say there's no distinct category of mediation privilege. But we then come to a modest proposition to extend mediation privilege. And this is a case, and a very interesting case, called Pentagon Food Group Limited versus Cadman. And this is a mediation that went a bit wrong, to put it mildly. In order to understand how it went a bit wrong, you have to understand who the parties were in Pentagon Food and Cadman, and what their respective position was. So Pentagon Food Group was a company owned by a gentleman called Mr. Khan, who also had another company called Khan Estates. Brian Cadman was the founder of B. Cadman Limited, BCL, but Mr. Cadman was one of these old-fashioned business people who doesn't seem to have drawn much of a distinction between himself, his businesses, his companies, his pension funds, his properties, or anything else. It was all him as far as he was concerned. And the judge in that case, His Honour Judge Tyndall, who was sitting as a High Court judge, observed that since Mr. Cadman didn't draw much of a distinction, it's not surprising that Mr. Khan didn't either. Mr. Khan thought he was dealing with Mr. Cadman. Pentagon Food Group Limited was the leasehold occupier of some industrial premises. The other parties, as I say, were Brian Cadman Limited, various members of the Cadman family, and the pension trustees, including an independent trustee. And the problem was this: it arose out of a fire at the premises. The problem, as the judge said, was that this was a claim for damages for alleged misrepresentation and breach of a settlement agreement derived in mediation, raising an interesting question about express and implied terms in settlement and liability for those representations, and of course the exception to the without prejudice rule. And it was in fact the third time the parties have argued about the fire to the property, which was called Portland House, following a fire in 2017, which Mr. Cadman at one point was alleging that Mr. Khan had actually burned the premises down himself in order to get out of the problem that he couldn't use the property for things that he wanted to because of some planning restrictions. In 2021, a claim was brought against Pentagon, but not by Mr. Cadman or Mrs. Cadman and Miss Cadman, who was the grown-up daughter, or the trustees of the pension fund, but rather by Brian Cadman Limited against Pentagon Foods. And the matter went to a mediation. And at the end of the mediation, the mediator signed off on an agreement which contained a very simple clause that none of us will be particularly surprised about, or consider in any way unusual. And it said this: that Khan Estates will, as soon as reasonably practicable, enter into a contract for the purchase from BCL, Brian Cadman Limited, of the freehold property of Portland House, the property that had been burned down. So in other words, one of Mr. Khan's separate companies was going to buy the property in its damaged condition, and that's how they were going to resolve the dispute about the unpaid rent. So far, so good. The slight problem was that BCL didn't actually own the land. It was owned by a combination of the trustees and the independent trustee, and nobody seems to have spotted this either during the litigation or during the course of the mediation. And a few days afterwards, this was discovered because someone for the first time did a land search and found out who actually owned the land. And it rather seems as though Mr. Cadman, first of all, rather changed his mind about the mediation, and then somewhat even more conveniently died, leaving his family to try and sort out the problem. So, what happens to mediation privilege in those situations? Well, the judge talked about mediation privilege as being not fuzzy any longer, and whether these could be raised by the mediator being called upon to give evidence. And he derived that from a previous case called Farm Assist and DEFRA. Because, said the judge, whilst there's no doubt that the contract was facilitated with skilled professional advice on all sides, at the end of a long day's mediation, well, it wasn't reduced into the sort of detail of writing that you might have after 3 weeks of negotiations to a commercial contract. So when interpreting the settlement, can the judge take into account the circumstances in which it was produced, even though that was during the course of a mediation? That's the question. And so the judge asked himself and proposed what he called a modest exception, or extension rather, to the without prejudice rules in mediation. The exception that admits evidence from negotiations of facts within the parties' knowledge where relevant to interpreting the contractual words should apply, where relevant, as to whether contractual terms should be implied. That was his first modest extension proposal. The second being that the privilege should be waived in the question when the question of fraud or undue influence or reckless misrepresentation is being considered in deciding whether or not the agreement negotiated at mediation should actually be enforced. And the outcome of the case was, in fact, that the judge found both breach and fraudulent, in the sense of reckless, misrepresentation. So what's the effect of Pentagon on mediation agreements? And the slide I'm going to show you now is, I think, the most important one within this discussion. And it's this. I think the net effect of Pentagon is, first of all, that the court can take into account the circumstances in which a mediation agreement was negotiated in order to try to apply the parties' true settlement intentions. Secondly, and perhaps this is less controversial or less of a development in the law, misrepresentation and material non-disclosures during a mediation can serve to vitiate the agreement. And third, that there is an emerging jurisprudence of mediation privilege because, and here we come to the nub of it, The judge appears to be saying that it's not necessary, or it may not be necessary, for mediation settlement agreements to read like a commercial contract or to run to hundreds of paragraphs. The court's entitled to take into account that this was an agreement hammered out at the end of a long day, and the parties have tried to record the essence of their agreement in a few sentences, probably late in the evening. And the role of the court is to consider those circumstances, even if that means going behind the privilege of mediation, in order to try to understand what it is they've actually agreed. And for me as a mediator, that gives me a bit of comfort, because one of the things that one always worries about when people go away with an agreement is, well, do they actually know what they've agreed? And should they have put more terms in there to avoid ambiguity? Pentagon appears to suggest that if there is an argument subsequently, the court's entitled to look at what they were really trying to achieve during the course of the mediation. That, I think, is the important extension of the law of privilege within mediations. How does this apply to a related subject of private financial dispute resolution and private ENE, and indeed arbitration? For those of you who don't do that kind of work, let me just tell you briefly what happens in a private financial dispute resolution hearing, or private ENE for that matter. The parties will attend with their counsel and their legal teams, and they will present the case to me as the private judge or private assessor, put their arguments forward. Sometimes some informal evidence is even taken, obviously not on oath. And then as the private FDR judge or private ENA judge, I will then say, right, well, go and have a cup of tea, and I will go away for an hour or so and give basically an indicative judgment, saying, well, if this were in front of me as an arbitrator, this is what I would do. And that's delivered in writing to the parties, who are then able to go away and think about it, maybe to come back and seek clarification, or as in the last case I did, to come back and say, well, if the facts were slightly different and there were these, what would you say then? And they spend the afternoon negotiating, and in most cases, 9 out of 10 cases I found, I think actually every case, they've settled. The question is, what happens if they don't? Should the material which has been disclosed or discussed in the course of that be available to be put before a subsequent court? And when I first drafted these slides, the conclusion I reached was there was almost no jurisprudence. I drafted these slides about a few months ago. And I spoke too soon, because questions that need to be considered are, can the written indication be relied on in subsequent proceedings if there's no settlement? What about costs? Is there any distinction between private FDR and the court-based system of financial dispute resolution? What happens about fraud, or for even for that matter, something arising under the Insolvency Act, where parties are using the opportunity to put assets out of the reach of their creditors? Is arbitration different? Does it come down to the agreement? These are the questions I was asking myself when I drafted these slides. And I decided there was almost no jurisprudence. And then almost immediately, BC and BC was decided by Mr. Justice Peel earlier this year. And this was a case of a private financial dispute resolution meeting in which this happened. Classic case, somebody walks out, slams the door behind them. And we've all got a few horror stories of that happening, very rarely, I hope. That's what happened in the private FDR meeting before the evaluator, in a very similar situation to what might happen in a mediation. When the matter went back to court, the aggrieved party on the other side put in their opening statement these words, incendiary words. Of course, today would have been the second day of the hearing, were it not for your client's retrograde decision to leave the building yesterday, not 30 minutes after receiving the evaluator's written indication, which tells the judge that an adverse indication was given and the party who stormed out didn't like it very much. And an objection was taken to that, and it was taken before Mr. Justice Peel, and he was asked to decide whether those words should be allowed into the written submissions being put forward by counsel. And he said no. Although this is not a traditional mediation, it's similar to how it works. And there are very few things that can actually be revealed as a result of a failed private evaluation. And there's 4 of them. First of all, whether it took place at all, whether the parties intended, because in the public system, the court has to be told whether or not a reasonable attempt was made for alternative dispute resolution. So did they turn up? Secondly, the parties can tell the judge the identity of the evaluator, the private judge, and the legal teams. Thirdly, the location. Not very controversial so far. But fourth, and I think this is probably the key point, which is going to give rise to further discussion, the length of the PFDR. So that what Mr. Justice Peel is saying is the judge subsequently, we can tell, well, it only lasted 15 minutes, and it won't take the trial judge very long to figure out which party stormed out and behaved unreasonably. So I think that's probably the key exception. What was actually said, however, that has to remain privileged. So I think that probably at the moment answers the question, what about private assessment? So that's what I wanted to say to you this morning. As I said earlier, this talk takes about half an hour, and we've dealt with our half an hour. I'm from College Chambers, and on the slide in front of you, if any of you have got phones with cameras, I'll leave that up for a second. If you point your phone at that QR code, then you'll be able to make contact with Chambers if you want to talk to us about this or other discussions that we've had on the subject of privilege. And I know this talk's been recorded, so you'll be able to pick it up a few days later after somebody's tidied up the few glitches that we had once or twice as it was proceeding. So that takes us to just after 9:30, which gives about 15 minutes for any discussion that anybody would like to raise. And I'll now stop sharing my screen.
Thanks very much, Derek. One person's asked whether it's possible to have a copy of the slides. Is that something you could supply?
I think you should already have that, or somebody has. Absolutely. Please take the slides.
Okay. Martin, I think you've
Martin
got
got
it,
it.
have
Jane
you?
Martin's got them, yeah.
Yeah.
If you send them to me, I can forward it to everybody then.
Will do.
Thanks. If anybody who's got any questions or comments can put their virtual hand up. Failing that, if you can just say whatever you would like to say. Any hands up yet, please?
Well, I've obviously stunned everybody into silence with that.
Put in the chat, Dave.
Either that or it's too early. Christine's got her actual hand up.
Christine.
Just needs to
Fire away,
unmute.
Christine.
Yes, hello, thank you. Sorry, I couldn't find my virtual one. So, yeah, very interesting. Thank you very much, Derek. Just interested, the net effect of Pentagon. I wonder what your thoughts are on this potentially sort of eroding some of the sort of raison d'etre of mediation and other sort of alternative dispute resolution, that if there's that sense that it could then be reopened as such by the courts, does that sort of put a slightly different flavour on the mediation process itself? Not articulated terribly well, but I hope
No, I know what you
understand.
mean. I try to give you an example. So about 8-9 years ago, I did a mediation as a mediator, which was all about the parties included a bankrupt person and his trustee in bankruptcy. And there was a big argument about what he'd been doing with various items of property. And before we could really get anywhere, we were trying to track down what he had done. So everybody agreed that rather than going away for the trustee to have one of these public private examinations before a district judge, which you can do in bankruptcy proceedings, the sensible thing to do would be to have an informal meeting where he would simply ask questions of the bankrupt in front of me. And I would just basically sit there. And if I thought the questions were inadmissible or shouldn't be asked and answered, I would say so, but it was up to him. And I warned everybody this was an informal process and that no one was obliged to answer the questions. And I also actually warned the bankrupt, you might be asked questions to which the trustee already knows the answer, so you're going to have to be truthful about it. And what happened was a load of questions were asked. quite a few of which the trustee already knew the answers to, and untruthful answers were given, or odd answers were given, and they didn't settle the case. About a year later, I got a letter from the clerk to the High Court judge who was now dealing with this case, saying, "Dear Mr. Marshall, this case is in front of me at the moment, and the bankrupt has given evidence saying X, Y, and Z, and someone's jumped up and said, well, that isn't what you told Mr. Marshall a year ago. Do you agree to waiving privilege?" And I said, well, it's not mine to waive, it's the parties. But if you want to know what I think, no, I don't agree. And by the way, here's the mediation agreement that says you can't. And that's what happened. So I think that's always been the problem, which is if somebody says something fraudulent during the course of a mediation, I think there's always been the risk of it being opened up. I don't think Pentagon Foods really alters that. Where I think Pentagon Foods does extend the idea of lifting the mediation privilege is precisely on the point of where the parties reach an agreement, but it's not clear exactly what they've agreed. And it's sort of an extension of the contract term, which we have in my Chambers agreement, which says that the parties can refer to the mediation if it's necessary for the purpose of implementation. And what the judge seems to be saying in that case is, well, in a commercial agreement, you just spent weeks deciding this, and there'd be 30 paragraphs. Here's a day's mediation. You can't seriously expect them to get everything down on paper at 9 o'clock at night. So I'm going to have to take a sensible view of it and find out what they really intended to agree. And actually, I think it's a piece of practical support to mediators, because it gives me some comfort that I haven't got to worry about getting 300 clauses down when the parties are broadly agreed. Because as soon as you start doing that, the agreement falls apart very often. So I don't really think it's undermining the mediation process. I think to the contrary, it's supporting it. But I may be proved wrong. You may have a good point.
We've got 3 virtual hands up. Firstly, Andrew Lancaster, please.
Hi, Andrew. I think you're on mute, Andrew. Andrew, we can't hear you.
Can you hear me now?
Yes, we can.
Oh, sorry, technical problems my end. Thanks very much indeed. I suppose the discomfort I was feeling as I was listening to your talk was that I very rarely take many notes at all as I'm mediating, because obviously mediators are quite busy rushing around. And what was going through my mind was, yikes, should I be taking more of a record of what's going on, and certainly in relation to the terms of the settlement itself? And I don't know whether you've got a view on that, because I think if I was asked for any records as a part of any subsequent court process, there wouldn't be much to show.
Well, nor do I actually, Andrew, take much by way of records. But the only thing I really do strictly write down is the offers, and I time them as well.
Right.
And I'm really strict about saying at 3:04 this was offered, and I very often will show it to the offerer, say, is that what you want me to carry across? Yes, I do. Good. And then I then have the process, and very often there'll be, we all know this, half a dozen offers and counter offers. So if anybody could ask me about how the discussions developed, and if I was required to do so, I could actually produce those notes. So
Yeah.
my view would be, as long as you keep really careful notes of what the offers are, that would be sufficient to assist the subsequent court to decide, well, what were the parties actually trying to resolve by this? And you can see the process. But I certainly wouldn't write, like you, I wouldn't write down everything I'm told, because you wouldn't be engaging with people if you did.
No, thanks very much. Thanks, Derek. Thanks.
Derek, on that same point, I'm told that some people ask the offeror to write the offer down themselves before it's passed. Do you support that idea?
Sometimes I do. If I think the parties haven't really formulated it properly themselves and I can't understand it, I will write it down, and that does often happen. Well, I mean, this is what we want to achieve. You just get them to do that. And someone, that's not going to happen, is it? You've got to write down precisely what it is. I mean, if they can't do it, I'll formulate it for them, but then I'll make them initial it to make sure I'm absolutely carrying across the right thing. But I think that can be a useful precaution.
Okay, thank you. Rian, I've got to you next, please.
Thank you. And thanks, Derek. That was really interesting. So I have two observations. One of them was a follow-on from what was previously said about the notes. And sometimes when representatives get together and draft the agreement, I struggle to get a copy of the agreement on the basis that I'm not in the agreement. I pushed for it and so far have always had one. But are there any, well, A, does anybody else have that issue? And secondly, is that what do you think about that?
I've got a very clear view on that. I do
Yeah.
not allow anybody to leave chambers or wherever I am without
Mm.
me having the top original copy of the agreement. And my chambers has got a file of hundreds of these, and we keep the originals. And twice we've been contacted by parties to say, we've lost the agreement. Do you have the copy? And we've been able to say we've got the original actually. So I think it's incredibly important that the mediator not only gets a copy or gets the, and for my case, I demand the original, so with Wet's signature on it if they're actually in the room.
Thank you.
We keep it.
Thank
Precisely,
you.
there isn't that argument. Oh, I think it's a very important precaution.
Yeah, no, absolutely. And secondly, I was in a conversation recently about international disputes and jurisdiction, and actually this point came up, and there was a variety of lawyers from different states in the US, and effectively nothing was resolved. Do we kind of have any idea of where this is going internationally? Obviously, we have a jurisdiction settled at the end, at the beginning, but do we know what might come internationally at any point?
Of my pay grade, I'm afraid.
Yeah, sure. No, that's fine. I just noted it because it was an interesting discussion and it was
Yeah,
actually last week. So thank you.
Roger may have the answer to that.
Before we come on to Roger, Derek, more or less on the same point. Some people expect the mediator to sign the mediation agreement, or
Yeah.
the settlement agreement. Do you think that's wise at all?
It's a personal matter. I do, actually. I do. But I don't think it's compulsory, and some people say they don't. I do, and I'm always named in the mediation agreement as well. And again, that's based on experience, really, because I've only had two that have gone wrong. One I've already told you about, and the other one, which went a bit wrong, was the parties reached a settlement in front of me on a Friday night, and one of the parties went off on a Monday morning, fired her legal team, completely changed her point of view, and repudiated the agreement. And the wronged party went straight to our local judge and said, "Look, I've got a mediation agreement here." And he said, "I've got three questions. Was this a proper mediation? Yes. Was it signed off? Yes. Who was the mediator? Did he sign it off? Yes. Where do I sign?" But that's just personal experience.
Thank you. Roger, we are coming to you now.
Yes, good morning. Thank you, Derek. Very interesting. I think what has been illustrated by the various comments so far is the broad range of practice and disciplines that we have as mediators. Because maybe because I was brought up well, not brought up, my professional life started as a solicitor, and so I was just trained instinctively to keep notes and contemporaneously, and I found that that's really stood me in good stead, and the process in good stead, by keeping timed notes of what's happened and who said what when, because we frequently had to refer back to it because X said they said A and Y said something different. So so that was the first point to note. And the second one was when you were talking about signing mediation agreements, because I've never signed a mediation agreement. I've never been asked to, and because it's not my settlement.
Well, the reason why I do, Roger, usually is because I say to the parties, I'm not going to let you leave here unless you have nothing's agreed till everything's agreed. Obviously, I'm not going to let you leave here if you've reached an agreement unless it's entirely written down and you're all absolutely happy. And when you are, then I'll sign it off, and I make them all do it. I say, right, everyone happy? Yep, signature on the bottom. And I feel that ties them to it, but it's a personal choice.
Yeah, interesting.
Thank you, Derek. Marcia, you have your hand up, I think.
Yes, Derek, nice to meet you and thanks for the
Hi, Marcia.
informative chat. I'm a retired police officer, so very interesting what work you're doing. I'm interested in with developments with AI and note taking as someone who's used to taking contemporaneous notes, what difference you think that makes, and do you use AI in terms of note taking and things like that at present in your practice?
I don't actually. I don't. I know it's very effective. I use it in another context. I use it because I chair a large charity, and we use AI to take notes of the board meetings. I know it's pretty accurate, but I haven't done it in mediation because I think it will. My feeling is it will be regarded as intrusive, but I don't know. I don't know. I just haven't done it.
Has anyone done it in this Zoom?
No, but I've done it in an investigation, and it caused all sorts of problems.
So, do you mind if we take one more question, actually, Dave? Because I've got to go back to go back to my panel in a couple of minutes.
Yeah, sure. Yeah,
Just take my question. In fact, I think he's got his hand up.
Yeah, one last question. Michael's got his hand up, please.
Derek, thank you. That was a fascinating and very clear talk. But one thing that struck me, and really struck me, was this idea of going back and effectively sort of reopening a settlement agreement. Of course, I get the logic which you've described. It's trying to capture everything at the end of a long day, but it is quite alarming. The agreement probably includes a clause. Most settlement agreements will include a clause that says this is the entire agreement. And certainly the promise we make to the participants is that nothing's agreed until it's written down and settled. The idea that it could then be reopened struck me really as quite alarming. Where do you think the limits are on this? Do you think that this is likely to arrive at a higher court that says, no, the parties have made their agreement, that's that? What do you think about that? As that reverberates?
I don't think I really agree with you that it's an alarming development, and I'll tell you for why. A mediation agreement is nothing more than that. It's offer, acceptance, and consideration. There's quite a lot of law on the extent to which you can look outside of the document. And I can't remember the name of the case offhand, but there is an authority, which I think is a Court of Appeal authority, which says that when you're looking at a commercial agreement, you are allowed to some extent to take into account extraneous matters to see what the parties actually meant to bring commercial sense to it. And I think it's no more than that. So I think it's a very limited extension. I don't think I don't agree with you that it's reopening it. What it's doing is making sense. It's making sense of the agreement. Supposing, for example, the parties had all signed off an agreement which involved the payment of a compensation sum, and what is written down is that A will pay B in compensation the sum of £100,000, when in fact everybody was talking about £10,000. And all of the offers back and forth were somewhere between 5 and 15, and they've settled at 10. I can't seriously believe any court's going to say, well, it's written down at £100,000, that's what it is. The court would make sense of it and say, no, it's perfectly obvious they were talking about £10,000. It's just a typing error. And I don't think it's much of a step to go beyond that to say, well, look, what did the parties really mean by this? Obviously, if it's involving a rewriting of the contract, then you can't possibly do that. But I think it is quite a modest extension. And I think it's a helpful one, actually, rather than an unhelpful one. But that's my view.
So you don't see it really as an extension over the court's normal process of interpreting any agreement?
I think it's applying the normal rules to what takes place in mediation, actually.
Okay.
That's how I see it.
That's less alarming.
I don't think you need to be alarmed at it. But of course, this is the decision of one circuit judge sitting as a high court judge. So who knows where it will go? As of yesterday, I gather one judge has said that that members of Silex can't run litigation. I can see there's some interesting appeals coming that way round. So one never knows where the law is going to go.
Yeah.
Thank you very much indeed for listening to me this morning.
Thank you.
I really do have to go because this panel's waiting for me. And I look forward to seeing you next week, but I am going to have to leave.
Thank you very much, Derek. All the comments I've had so far have been very positive. Thank you.
Thanks very much indeed, everybody.
And enjoy your day at the races.
Thank you very much. Bye-bye, everybody.
Bye-bye.